the property management industry, fair housing offenses are considered especially troubling. In the United States, a dedicated fair housing attorney, Leslie Tucker, provides case explanations and best practices. These are some cases.
Hello, everyone, and welcome to the Fair Housing Insiders Case Files. I'm Jonathan, your host, and today we are examining a case that illustrates how state regulations can intersect with fair housing obligations. Joining me is Leslie, a fair housing attorney with extensive experience in fair housing law. Leslie, welcome back.
Thanks, Jonathan. Glad to be here.
Always glad to have you on this show. Appreciate and look forward to your insight on today's case, which is United States versus Commonwealth of Pennsylvania. And this case addresses whether a state's building code can inadvertently create barriers to housing for individuals with disabilities. It's a critical issue for property managers who need to stay informed about fair housing requirements. So, can you provide us a little overview of the case?
Of course. The case involves Pennsylvania's Uniform Construction Code, which is the state's building code. This particular code has a specific requirement for what the state calls community homes, which is housing where in-house care is provided to individuals with an intellectual disability or autism. These community homes, which are intended to be very small, no more than 4 residents at a time, are also intended to be integrated into the community. So they're typically located within existing single-family homes, townhomes, apartments. So what the code says is that for these community homes, there must be an automatic sprinkler system installed, regardless of the age of the building. This case is about sprinkler systems. The government argues, in comparison, that other housing types, like just regular single-family homes, where no disabled people are living, in-home daycare centers, nursing homes, are not subject to the same requirement. The government alleges that this particular code discriminates against individuals with disabilities because it imposes a significant financial and logistical burden on these community homes, which in turn restricts housing options for those residents.
Got it. Okay. So it seems like this is a safety precaution, I guess, that would benefit those living in community homes. So why is the government arguing that it is discriminatory?
Well, under the Fair Housing Act, policies that disproportionately affect protected groups, like individuals with disabilities, they have to be narrowly tailored to address kind of specific needs. Some of the key arguments in the complaint are that community homes are required to have support staff in the residence at all times, that the community homes are small, like I said, no more than 4 residents at a time. Residents who live in community homes must, by regulation, be able to evacuate the home within a couple of minutes. I think they said 2.5 minutes. And many individuals who live in this type of housing are capable of evacuating without any assistance at all. So the government's issue with the state code is that it makes no attempt to distinguish between the ability of different individuals. It just instead creates this kind of strict and, in many cases, burdensome requirement across the board. So essentially, that means that any older single-family house that doesn't already have a sprinkler system, and really a lot wouldn't, as we know, they would have to have it installed before it could be converted into a community home. Any community home located in multifamily housing, so an apartment, would have to ensure that that apartment community already had a sprinkler system in place. The complaint states that the installation of an automatic sprinkler system can range from anywhere between $10,000 to $30,000. So in this way, the plaintiff argues that the code requirement is limiting and burdensome for these individuals who live in this housing.
Yeah. Okay. Thank you for the explanation. Yeah. Sprinkler systems are expensive. So what are the central legal questions that are raised in this case?
Yeah. So there's three main legal questions. One, does the sprinkler requirement amount to discriminatory treatment by raising these additional obligations? Does it create a barrier to housing access for individuals with disabilities? And the third is, did the state fail to consider possible reasonable accommodations that could meet these same safety goals without creating the barriers?
Got it. Very good. So are there specific examples from the case that highlight these issues you mentioned?
Yeah, the complaint does include a few examples of one community home operator was faced with extensive delays and expenses while installing the necessary sprinkler system. So the home opening was in turn delayed. They went into a situation where some water utilities required infrastructure changes to the facility so they could, comply with this rule. So there weren't a ton of examples, but yes, they did include a few.
Got it. Okay. So just listening to your feedback and highlighting some points from this case, it seems like they're kind of trying to find a balance between ensuring safety and maintaining accessibility. I'm sure the outcome of this case may influence how courts evaluate building codes and similar regulations under the Fair Housing Act. What do you think?
Yeah, definitely. And I agree. Safety is obviously important, but it has to be implemented in a way that still allows for housing choice and access. And since I think it's really important to kind of acknowledge both sides of the argument, I just want to note that in defense, the state does present a number of different arguments, but one of the arguments that it does raise is that currently there are about 5,600 community homes operating. They're housing over 12,000 disabled individuals. So they kind of argue that, despite these code requirements, there are a large number of community homes still in operation. So it doesn't, the argument is it doesn't seem to be hindering the operation of this type of housing.
Got it. Okay. So as we wrap today's episode up, what are some key takeaways from this case for our audience, our property management professionals who are listening today?
Yes. I guess just to reiterate, I think the primary takeaway is that local regulations, even those that are designed to promote safety, they have to be kind of implemented and examined to make sure that they don't disproportionately impact protected groups under the Fair Housing Act. And property managers and housing providers aren't making these rules. They're not making state regulations, right? And they are required to follow them. But as housing providers operating in a state with these types of requirements, you can still advocate for equitable solutions when necessary.
Got it. As always, thank you, Leslie. Great insights. We appreciate you explaining this and dissecting it in a way for our audience to be able to understand how it applies to them. And it's clear that fair housing compliance requires ongoing attention to legal requirements and practical impacts.
Yes, thanks, Jonathan. It's always a pleasure.
So for our listeners, thank you for tuning in. You rock. You're awesome. We are grateful for you. Be sure to subscribe for more insights into fair housing laws and best practices. Until next time, let's continue to build fair and accessible housing communities. Take care, everyone.